continent. And I should point out that Professor Priti Saxena is not only the first time on this conference, but she is a very famous professor in human rights field in India, and it's really interesting to know what you think about digital technologies and legal regulation in India on the relevant period. Thank you for joining us, and the floor is yours.
Thank you so much. Am I audible?
Yeah, it's okay.
So, yeah. So the topic, as you told, that is the Indian perspective on the digital sovereignty. I'm very, very thankful to you, Professor Yulia, for giving me the opportunity to share my views in this conference, which is organized by you. And I would also like to thank my colleague, Dr. Rashwet, and my husband, Dr. S.D.Sharma, who have given some material for preparing this presentation on this digital sovereignty. I also like to thank the authors of various articles and various research papers on which I have consulted with for preparing this presentation. For the purpose of understanding, I have divided my presentation in three parts. The first, I'll be discussing in short the sovereignty and digital sovereignty. The second part is the new Digital Personal Data Protection Bill of 2022, which has been opened and introduced in India very recently, that is on 18th November itself. And thirdly, the present status of the digital sovereignty in India. So the concept of sovereignty that can be related back in the work of Machiavelli, Bodin, or Hobbes. And sovereignty, as we know, is a way to the supreme authority political entity. This is something which is fine in the international law. The very supreme law of the land, that is the Constitution. The Constitution begins with the word of the India is a sovereign, socialist, secular, democratic republic. Coming to the digital sovereignty. The term digital sovereignty, which is also known as the cyber sovereignty, tech sovereignty, internet sovereignty, data sovereignty, or with many more names. So, this refers to the borderless nature of the internet. And this is not having a confined geographical area. So, this digital sovereignty refers to the fact that a state, that is government, or an organization must establish its authority to exercise its power in the cyberspace. Basically, it focuses on the issues like technological dependence or the control over personal data of the user. In India, there is evidence of digital transformation as a result of the digital governance. India today is the home of more than 75 crore smartphones, 130 crore Aadhaar cards, more than 80 to 85 crore internet users, and has 4G, but now we are rushing towards the 5G also. So India is said to be the second largest population in the world, and also it is using digital platforms. With a majority of the young consumers, they are emerging as a great land of the information in India. So India is also becoming one of the largest sources of the commercial useful data in the world. Therefore, in a world which is witnessing a rapid advancement of technology, data privacy, and personal data protection, that assumes a significant importance to safeguard the right to privacy of an individual and the authority or the sovereignty of the state, as just Professor Antonita was discussing about. Furthermore, the advent of the social media has given rise to several platforms we all know, seeking and storing the personal data of the individual. And this raises a question of the personal digital sovereignty, in which an individual should have the control over her data, device, software, hardware, whatever technology he or she is using. And one of the most common notions that relates to this is the issue of the privacy. The issue of privacy has become an important battle for organization and movements alike. It also, in this context, that the rise of the encrypted tools for the masses, we are all using the Signal, Telegram, WhatsApp, and other encrypted tools, and that have become an important focus for the hacker community also. So the use of encryption can be understood through the prism of personal digital sovereignty, which includes the right to privacy, in the sense that it allows the individuals to have the perception of ownership, ownership over the content of their discussions with the others, while uh, they are leaving the metadata in the clear. Whatever I am speaking in front of all of you, this is the point where this data is going to be preserved. And in such a scenario, it becomes very, very crucial for the state also to lay down the guidelines to govern how such personal data and the digital sovereignty should be protected. Presently, we know that there are 137 or more countries out of 194 in the world who are having the legislation for the protection of data and privacy. In a follow up to this all, the Indian government has also introduced very recently this Digital Personal Data Protection Bill. This is the fourth iteration after 2018, 2019, 2021, and this is the last one. And we are supposing and we are hoping also that in the coming budget session in February 2023, we'll get some act which is going to protect the data, Digital Personal Data Protection Act. Some of the very key facts and important definitions which are the part of this bill, which is open for the comment of the public, and the public is invited to comment on the shortcomings or some loopholes in the bill up to 17th December. So we are hoping that some good suggestions would be given by the public in India and the users basically. And those comments and those recommendations will be incorporated in the law. But presently, what the law in India exists regarding this bill on the personal data protection, that is related to the definition of data fiduciary and data principal, basically. Now, data fiduciary, that is in that bill, is any person, any who is alone or in conjunction with the other persons, determines the purpose and the means of the processing of the personal data. So, first thing which is very important is that the purpose for which the data is being stored. Secondly, the data principle is defined in our bill, that is the individual to whom the personal data relates, and where such individual is a child, that includes the parents or the lawful guardian of such a child. So up to the age of 18 years, if there is a child, then the consent is to be taken from that data principle from the natural guardian or the lawful guardian. Otherwise, the person, the principal is said to be having the right to have the data which relates to his individuality. Then data processor, any person who processes the personal data on behalf of a data fiduciary. So these three things are very importantly given in this bill: data fiduciary, data principal, and data processor. And one thing which is also very important, because I am a woman, so in view of the women empowerment, this bill is going to use the pronouns of her and she instead of he and his, because all the acts which we are having in our country, the pronouns is the he and his, but this is the first one where we are finding that the pronouns are her and she. They have been used for an individual irrespective of the gender. Now, under this act, there are certain rights and duties of the data principals also. For example, the data principals have the right to know whether a data fiduciary is processing their data, and in such cases, the summary of the personal data, activities of the fiduciary, the identities of all those with whom the data has been shared, and any other information as may be prescribed. So that has to be given to the user. Secondly, the data principal has the right to request for the correction of. The correction of the data may be requested. This is a right. At the same time, if the data principal, that is the person, individual who is giving the data, if he or she wants that the data should be erased, then this is also one of the right of the data principal. So the right to erasure of data is also given in this bill. Then data principal have the right to register the grievances with such fiduciaries if he is not satisfied with the Data Protection Board of India. So this is also one of the provision which is going to be the part of the Data Protection Bill, that is Data Protection Board of India. Then data principal shall also have the right to nominate any person who can exercise their right after their death or incapacitation. Suppose if the individual who has stored some of the data, who has given some data on air, and he dies, then who will be the owner of that data? So he can nominate that any person can exercise his right after his death, and at the same time, if the person is going to be incapable by virtue of some disability or something like other that he is not able to use, then he can also nominate any person who can use his right. There are also certain duties for the data principals in this bill, that is, compliance would be there, and if it is not compliant, then the penalty provisions are also there. For example, data principal should not raise any false or frivolous complaint, because he can complain to the data protection board, but this should not be false or frivolous. At the same time, the data principal should not furnish any false information or suppressing material information or impersonate another person while using the media platforms. Then he should not only provide verifiably authentic information while correcting or erasing the data, because these are the two rights: right to have the request for the correction and the request for the erasure of the data. So when the data principal is making this request, then it should be verifiable and authentic that whatever he is going to correct and erase, that should be a correct information. So these are the data principles rights and duties in the bill. Then regarding the transfer of personal data outside India, this is very important and crucial point, which has already been discussed by the earlier speakers here also. And this is related to the data fiduciaries that may transfer the data. Because in India, you see, it's not only the private companies who are the data fiduciaries, but the government also as a part which is implying the e-governance, and data governance is in prevalence. So the government is also one of the data fiduciary, and largest data fiduciary is the government also. So the data fiduciary may transfer data to approved countries or the territories, and should give respite to big tech companies like Meta and Alphabet, which were hoping for the same. and such approval will be given by the central government, and the terms and conditions will also be specified. So we see that there is going to be some rules, regulations to be framed by the central government in this respect regarding the transfer of personal data outside India, and therefore there is no localization of the data as such. Then the government can access to the data also. The government has the authority to exempt any state instrumentality from the provisions of the bill by a notification for reasons that if there is some case of the sovereignty and integrity of India or the security of the state, some friendly relations with the foreign states, maintaining public order. So, if these are the grounds, then the government can access the data also. There is no exemption on that point, and the state can interfere into that. So, at the same time, there is no collection limitation, there is no purpose limitation, or there is no storage limitation on the part of the government. So every type of the data can be collected. This is going to be very, very harsh for the data principles also, and we'll have to see that what comments and what recommendations are being given by the data principles in this respect. Then, as I told you, the data protection board is also to be there, which has to be established by the central government, and that will have the power of the civil court in India, and the appeal from the decisions of the data protection board will be going to the high court directly, and then the data protection board of India will have the power to impose some penalties on the data fiduciaries and the data principals for violating any of the provisions. But so far as the quantum of this penalty is concerned, it is to be determined by the data protection board, and the penalties for non-compliance are very, very hefty, which includes up to 250 crore rupees. That is the penalty which has been given in the schedule 1 of this provision of this data protection bill. Now we see that the right to privacy has been held to be a fundamental right in India. In 2017 by the Supreme Court in very important case of KS Swami. And we see that we don't have any law on the data protection as yet, and this is the bill which is now to be produced in the parliament, on which after that it would become the act. So there are certain points which are important for understanding the status of the sovereignty, digital sovereignty, particularly first. While protecting the rights of the data principle, the data protection laws need to ensure that the compliance for data fiduciaries are not hard, so that even the legal processing may not become impossible. This is one. The challenge lies in the finding an adequate balance between the right to privacy of the data principles on the one hand and reasonable exceptions. As I told you, the security, sovereignty of the state, public order, all these things. On the other hand, that is data principle and data fiduciary. That is where the government is producing of the personal data is concerned. Thirdly, we have to see that given the rate at which the technology evolves, an optimum data protection law design needs to be the future proof. It should not be like unduly detailed, so that in future we cannot change in the emerging situations, because we all know that the technology is developing at an exponentially speed, while the law cannot match the pace of the technology. So our law should be in that system. We can match the speed of the technology through our law. And finally, the law needs to be designed for a framework of the rights and remedies that is readily accessible by data principles, given their unequal bargaining power with this respect to the data fiduciaries, because the data principle is an individual. Data fiduciaries are the big, big companies, the government on the other hand. So, how to make a balance between these two? It becomes very important. And the concept which has been introduced in this bill is of the deemed consent. That is also going to be very important, because this bill is not giving the data principle, the right to be forgotten or the right of the data portability. These two things are very important. So the main question remains is of the sovereignty in the era of technology. Who has digital sovereignty? The data principle or the data fiduciaries? For me, in a democratic nation like India, a balance is very much required between the data fiduciaries, reasonable requirements, and the data principles' right to privacy. None can be absolutely sovereign digitally because the issue needs to be settled. There are three actors in digital world, and where we place the sovereignty shall determine the nature of the other issues, especially the digital human rights. State. If digital sovereignty is placed on the state, states are trying very hard. In the state, then there is a fear of surveillance society, like the Orwellian state. Secondly, if the tech giants want their hold over the digital space, resulting into privatization of the digital space. And thirdly, and most suitably, that people, individual, but there is a fear of unrestricted freedom leading to the fake news and fake information. So, in this scenario, who is going to be digital sovereign? The state, the multi tech companies, or the individual? This is a question which needs an answer, and the seminars and conferences like this are the platform where we can discuss who is digitally sovereign. So, with these words, I would like to thank the organizers for giving me the opportunity to share my views on the digital sovereignty in Indian perspective. And if there is any question on this, I would be very happy to give the answers to this. Thank you so much.